obviously because I've turned the subtitles. And
Testing.
Hi, Heather or David, can you hear me?
Yes, James. Yeah.
Thanks.
Good afternoon, everyone. The inquiry is resumed. I assume everyone can hear me. Is that right?
Yes, sir, loud and clear. Thank you.
Okay, thank you. So today's scheduled to hear closings, firstly from the council and then from the appellant side. Before we hear those, does anybody want to raise anything in relation to the inquiry?
No, sir, only to say that Mr. Neil has helpfully just now sent me a copy of his closing, and I am going to finalise mine in response to that whilst he's speaking, and then I shall send him a copy before I read mine out later on. I hope that's Oh, and also email it to you, sir, via your case officer at the same time.
Yes, that's fine. That's fine. So hopefully that comes through in time. If it doesn't, I don't want that to sort of slow you down. So I'll assume it will work in that fashion. So I'll invite firstly Mr. Neil to make his closing.
Thank you, sir. And I've sent those submissions at the same time, sending to Ms. Sargent to you, sir, via your case officer. I doubt you've received them yet, but I'll just
No.
press on if I may.
Yes, I've just checked and I've not received it yet.
Okay. Well, just to if you're happy for me to press on, sir,
I am.
I'll read. I'm grateful. So these are the closing submissions by Hart District Council in response to the appeal brought by Madicott Limited, the appellant, under Section 78 of the Town and Country Planning Act against the refusal of the council to grant planning permission. I've set out the full reference to it in my written submissions. I won't repeat that. At the outset of the council of the inquiry, as stated at the outset of the inquiry, the council maintains reason for refusal 2 and 3, relating to the design and negative effect on the character of Elburn Heath, and also reason for refusal 1 on retail impact. In light of that, the submissions focus on the 2 key issues identified by you, sir, at the start of the inquiry, namely the retail impact and whether there would be a adverse impact on the vitality and viability of the town centre, and secondly, the acceptability of the proposed design and the impact to the character and appearance of the area, inclusive of tree loss. My submissions will then address at the end the question of the overall planning balance. So just turning to retail impact, first of all, policy ED4 states that development for retail and or leisure with a gross floor space exceeding 1,000 square meters in edge of outer tension locations will be supported if, following an impact assessment, it would not have a significant adverse impact on existing centres. This reflects paragraph 95 of the NPPF, which states that where an application is likely to have a significant adverse impact on one or more of the considerations in paragraph 94, should be refused. Those considerations refer to the impact of the proposal on town centre vitality and viability, including local consumer choice and trade in the town centre and the wider retail catchment, as applicable to the scale and nature of the scheme. In light of that, it's therefore common ground that the key policy test in relation to the retail impact of the proposal is whether it would have a significant adverse impact on Fleet town centre's vitality and viability. The council's position is, in light of the evidence submitted and heard at this inquiry, that it is clear that there would be a significant adverse impact on Fleet town centre's vitality and viability. The key issues between the experts essentially relates to firstly the question of impact on Waitrose store, and if it would close, and if so, what consequent impact that would have on the Hart shopping centre, and then thirdly, what the consequent impact would ultimately be on the vitality and viability of the Fleet town centre. So, turning to the key issue, would Waitrose close? Just looking at Waitrose's current performance, first of all, the question of what risk to Waitrose the proposed Lidl store poses is clearly informed by a realistic idea of what Waitrose's current performance is. This is relevant not just in its own right, because the more underperforming it is, the more vulnerable it would be, but it is also relevant to the question of what trade diversion it might suffer. Mr. Singer accepted that in principle the current trading performance of the store was relevant to any assessment of trade diversion, and an important part of company performance is turnover. However, as Ms. Reeves explained, it was not necessary for her to give actual alternative figures, whether for company performance or trade diversion. This is not least because she stated that she had confidence in the high-level trends and in terms of relative performance. And her view was that if a store is so vulnerable, she considered even a small impact would be relevant. And I've given you the don't want to argue about exactly verbatim what she said, but I've given you these references in my closing to her response to Ms. Sargent in cross-examination. And here there is already evidence that the store in issue, Waitrose, was sufficiently concerned about the impact by Lidl that it submitted not just one objection, but two successive objections. The two first plan objections, of course, do not state in terms that Waitrose would close for the reasons Ms. Reeve explained in relation to staff morale, etc. But she explained that it was highly unusual for Waitrose to object. Significant weight can and should be placed on this fact. But in any event, Ms. Reeves has provided some alternative figures in her evidence to this inquiry. Ms. Reeves' assessment was that Waitrose performance was likely to be higher than the figures contained in Mr. Singer's May 2026 Retail Impact Assessment. Her raw evidence was that it was somewhere between the weighted and unweighted ranges for Waitrose turnover, i.e. those ranges she set out in her proofs at tables CRA9 and CRA10, derived from the NEMS survey. That range was between 6.68 million and 11.86 million. Although she heavily caveated that this as it was based on unweighted survey results, which was not an approach she endorsed, and was rightly reluctant to give a particular figure, she also explained in answers in cross-examination that if she had to give a particular figure, she would go to the upper end of that range and therefore use the unweighted figure of 11.86 million. Her evidence was on this basis it would be around 65% of the Waitrose benchmark, i.e. the company average turnover for a store of this size. Mr. Singer's assessment of Waitrose's current annual turnover was based entirely on the 2023 home survey. That produced the survey-derived turnover of 9.3 million for Waitrose in the design year of 2029, leading to a figure of 57% of the benchmark figure. The reason for that difference between the two experts on the Waitrose turnover figures, and therefore performance against benchmark, goes to a fundamental point of difference between Ms. Singer and Ms. Reeve, which extends beyond merely Waitrose's performance against benchmark, namely Mr. Singer's reliance on the 2023 home survey results. It is common ground that the survey produced an overestimate of other stores, particularly Marks and Spencer's, where the survey resulted in a calculation of turnover of over 8.5 times the company benchmark. That is a clear indicator that reliance on the 2023 home survey results, without interrogation and if necessary adjustment, was unreasonable. Mr. Singer accepted that he could make adjustments to the 2023 results, home survey results, if they produced figures that were unrealistic compared to what was going on the ground. For example, he adjusted the Sainsbury's Hook figures to reflect the fact that they had not actually reached trading maturity. Yet he did not carry out such an exercise in relation to 2023 survey results in relation to any of the 3 Fleet Town Centre stores. In short, when the survey results produce figures so obviously unrealistic, Mr. Singer should have paused to interrogate why that was the case and apply professional judgment as to what level of adjustment would be appropriate. There is no evidence he did such an exercise, and this is a fundamental flaw in his approach, not just in relation to Waitrose's performance, but in relation to the 2 other supermarkets in the town centre. His failure to do so means that significantly less weight should be placed on his calculation than the assessment carried out by Ms. Reeves. Again, not just in relation to Waitrose, but all the supermarkets, town centre, and that Ms. Reeves' assessment should be preferred. Specifically in terms of Waitrose, its performance is actually higher relative to benchmark, and this is in turn relative to the degree of trade diversion that it will suffer. So just turning to the trade diversion from Waitrose, or the question of the trade diversion from Waitrose. The trade diversion to the appeal proposal is clearly going to be greater than that suggested by Mr. Singer in his May 2026 RAA. He'd identified in the May 2026 RAA that the SOLAS impact, i.e. an impact without taking into account committed developments which received planning permission coming forward, was just 1.4%, and in absolute terms was a drop of 0.12 million. That figure, of course, increased slightly in his rebuttal to 0.3 million. That level of trade diversion from Waitrose is unrealistic. Miss Reeves' evidence was it was likely to suffer between 1 to 2 million. That was based on her view that there was not a significant difference between Sainsbury's and Waitrose in this regard. And Mr. Singer's own evidence suggested that Sainsbury's will lose approximately 2.4 million. That's set out in Table 14. Miss Reeves' view, i.e. one based on a comparison with Sainsbury's, was entirely reasonable. The level of trade diversion, of course, depends on the degree to which stores compete. And in this regard, Waitrose clearly would compete directly with Lidl. This was precisely what Mr. Singh's own written evidence stated. His proof of evidence stated in terms, the food store proposed in the appeal scheme would compete most directly with the existing food stores, open brackets, Sainsbury's, Waitrose, and M&S Simply Food Store. His attempt to distance himself from this remark in cross-examination, and his suggestion he was just looking at all the stores collectively, was in my submission unconvincing, and no answer to what he clearly stated in his written evidence. Mr. Singh's evidence focused on the difference in price points between these stores nationally, and on that basis took the view that Sainsbury's was more likely to compete with Lidl than Waitrose. Whilst it is of course true that nationally Sainsbury's is closer in price to Lidl than Waitrose, as Ms. Reeves explained, other factors are relevant, including size, proximity, and ranges, i.e. Offer ranges. For these reasons, the particular Waitrose here in Fleet clearly provides the most similar offer in terms of made food shopping. In further support of Ms. Reeves' view that Waitrose here would compete with Lidl, is the fact that trade diversion was expected when Aldi moved into the area and opened a store at Church Crookham. 4 million was forecast to be lost from Waitrose and Sainsbury's. And you recall, so that was in the Appendix 4 of her proof. Of course, this was just a forecast, but the underperformance in Waitrose and its fall in market shares in recent years, which appears to be common ground, see, for example, the Table 4 of the May 26 RIC, is also entirely consistent with Miss Reeves' alternative explanation to that provided by Mr. Singer, namely that Waitrose has borne the brunt of previous impacts from the opening of other stores, such as Aldi and Church Crookham. Miss Reeves' evidence was clear that any further loss of trade from Waitrose was likely to lead to closure of this store. That was an entirely reasonable conclusion to reach, given not on any analysis is performing significantly under benchmark. In short, Waitrose would compete directly with Lidl, and the original trade diversion estimate of just 1.4% is a considerable underestimate by Mr. Singer, a point with which First Plan on behalf of Waitrose agree. It would clearly be greater than Mr. Singer suggests if one were to use the 65% of benchmark figure and 10% of trade diversion suggested by First Plan. That would result in an 8.4% drop of turnover on a SOLAS impact, as Mr. Singer himself, actually to his credit because he did the maths, explained in his evidence in chief. Mr. Singer refused to specify what degree of trade diversion would lead him to conclude that Waitrose would be threatened. However, whilst the precise figure of trade diversion cannot be ascertained with any degree of certainty, given the unreliability of the 2023 home survey results, it is clear that a drop of that magnitude would mean that it is likely that Waitrose, given its current vulnerability, would close. None of this impact on Waitrose is materially offset by the closure of the M&S Simply Food Store announced on the 3rd of June. Miss Reeves entirely reasonably accepted that there would be some diversion back to Waitrose, but Mr. Singer's estimate that Waitrose receive an additional 5.16 million is fundamentally flawed for at least two reasons. First, it's premised on an overall turnover figure for M&S of 18 million, which is derived from the 2023 home survey, which is clearly a significant, if not gross, overestimate. Goes back to the 8.5 times company benchmark point. Secondly, the 30-10 split of the 40% of that overall turnover advanced by Ms. Singer is premised, at least in part, on Waitrose performing a top-up shopping role. Now, in terms of that top-up shopping role, Ms. Reeves explained how the fleet Waitrose performs less of a top-up role than Sainsbury's, at least in terms of its store composition, for example, its specialist counters, etc. Its role is clearly and primarily as a main feed store, not for top-up shopping. She explained how the Sainsbury's almost immediately next door to M&S is more suited to top-up shopping. For example, it does not offer a wide range of fruit and vegetables, etc. Its proximity to M&S, and therefore the fact that it would be the most convenient alternative to it, means that it is likely to absorb at least half of the trade from M&S's closure that would remain in the town centre. So 20-20 split, therefore, is far more reasonable. Mr. Singer's analysis that Waitrose performs more of a top-up role for fleet residents than Sainsbury's was inconsistent with the existence in the Waitrose store of the very features of a store which Mr. Singer previously identified as being those related to larger format superstores. And that was set out in his earlier proof of evidence. Furthermore, neither party's experts took into account the M&S store opening at Farnham originally. Ms. Reeves explained that this would take at least some of the die-hard M&S customers away from Fleet Town Centre altogether, offsetting any increase. This is a further reason why any increased trade from M&S would only result in a relatively small uplift. So just turning to the impact on Hart Shopping Centre, if Waitrose closes, it's clear that there would be a knock-on impact on the Hart Shopping Centre, which is itself a significant part of the primary shopping area, an area acknowledged in local plan meriting particular policy protection over and above the rest of the town centre. As Ms. Reeves explained her evidence, the Hart Shopping Centre is already vulnerable. Vacancy levels in the Hart Shopping Centre are already high. It's true that there's been a historic issue with high vacancy levels in the Hart Shopping Centre. Ms. Reeves noted that based on the retail study in 2014, the RLTCS. As Ms. Reeves noted, the RLTCS noted that in 2015, a third of the 28 units were vacant. And in any event, the HSC is now in an even worse position in 2015. Vacancies have risen from 10 in 2015 to 20 by 2022. All of this points to the Hart Shopping Centre not being able to withstand the closure of its key anchor store. In that regard, it is common ground that Waitrose is the convenience food anchor store for the Hart Shopping Centre. Therefore, it is clearly the most important store in terms of creating footfall in the Hart Shopping Centre. The fact that there's space for an anchor tenant at the other end of the store, it should be at the other end of the centre, previously occupied by M&Co, and now a bed and furniture retailer, does not mean that this store plays the same anchoring role, nor is there any evidence that a store of this type generates the same level of footfall as Waitrose. Ms. Reeves' conclusion, therefore, that the loss of footfall to Waitrose would lead to the eventual closure of the Hart Shopping Centre was entirely reasonable. So just turning to the impact on the vitality and viability of the Fleet Town Centre, if, as Ms. Reeves rightly indicates, the Hart Shopping Centre were to close, that would mean the loss of approximately 10,000 square meters of floor space, which equates between a quarter and a fifth of all town centre space in Fleet Town Centre. The hot shopping centre itself contains nearly all the major national retailers, the presence of which, according to Mr. Singh's own evidence, were factors in indicating the overall health of the town centre. There is no evidence that they would take up vacancies elsewhere in the town centre. The closure of the Hart shopping centre and its car park and the loss of these national retailers would clearly have a significant impact on Fleet Town Centre's vitality and viability. Mr. Singh's proof of evidence contains no analysis of what the implications for the Hart shopping centre would be were Waitrose to close, and in turn what the implications on Fleet Town Centre would be were the Hart shopping centre to close. Instead, his analysis is entirely predicated on an overall analysis of loss of convenience store turnover and his conclusion that Fleet Town Centre is performing satisfactorily relative to national levels, rather than an analysis on the knock-on impacts of Waitrose to the Hart shopping centre, and the effects in turn of the wholesale loss of the Hart shopping centre to the town centre. Furthermore, the appellant has agreed that all three stores, Waitrose, Sainsbury's and M&S, are anchor stores. Given M&S's imminent closure, Waitrose will now be one of just two anchor food stores left in the town centre. That town centre will already suffer the loss of should be actually the loss of 60% of M&S turnover from the town centre, which will clearly weaken it. Fleet Town Centre will now lose one of its two remaining anchor stores. This in itself would clearly result in a significant adverse impact, regardless of what happens to the Hart shopping centre, as Miss Reeves explains in her addendum proof of evidence. In summary, drawing all of this together, the introduction of the Lidl store would lead to the likely closure of Waitrose, the closure of the Hart shopping centre, and a significant adverse impact on the vitality and viability of Fleet Town Centre. It would therefore be contrary to policy ED4 of the local plan and paragraph 95 of the NPPF. Just turning to the second of the two main issues, design and impact on the character of the area. These issues are taken together because the question of design is clearly relevant to the question of impact on the character of the area. I'm just going to set up briefly the key policies, key development plan policies relating to design. The key development plan policy relating to design and character is policy MBE 9, which refers to the need for proposals to seek to achieve a high quality design to positively contribute to the overall area. Save policy Gen 1 is also relevant, which refers to development needing to be in keeping with local character by virtue, amongst other things, of their design. Policy MB9 refers to, I'm just going to summarise this, all development seeking to achieve a high quality design and positively contribute to the overall character of the area. Criterion A refers to promoting and reflecting the distinctive qualities of the surroundings in terms of proposed scale, density, mass and height. Choice of building materials. Criterion D refers to development respecting local landscape character and significantly incorporating any on-site or adjoining landscape features such as trees. The appellant appeared to suggest, at least in the questions put to Mr. Raper, that the policy can be met by simply meeting the relevant criteria set out above, i.e. that there's no self-standing requirement for development to achieve a high quality design. That's clearly a flawed interpretation of policy. The aim of the policy is clearly to achieve high quality design. If we're only to have regard to the criteria, they do not cover all aspects relevant to the question of design. There are other requirements relating to design, in this case matters such as roof form, etc., which on the appellant's interpretation could lead to poor design, yet result in policy compliance. That doesn't accord common sense. It would mean the aim of the policy, which the appellant's own planning witness agreed was to achieve high quality design, would not be achieved if the question of compliance is solely restricted to those criteria. Nor is such an interpretation consistent to the context to which the policy appears in the local plan. The explanatory text of the policy is relevant to construing it. The explanatory text refers expressly to high quality design at paragraph 304 and at paragraph 305. That paragraph in particular states in terms, proposals should not only be of a high quality in design terms, but in many locations across the district, they'll need to protect and enhance historic character of existing development. That makes it clear that read in context, policy MBE 9 requires high quality design. The council's concerns regarding the scheme were primarily its concerns with design and therefore compliance with MBE 9, and it's correct that its reasons for refusal did not refer to the council's landscape policy MBE 2. Nor in giving evidence on design and character did Mr. Raper suggest there was a conflict with MBE 2. There's nothing inconsistent with that. It's not known whether the appellant's going to pursue this point. Since its planning witness, Mr. Moy, appeared to accept there was nothing inconsistent about the council having concerns with MBE 9, compliance with MBE 9, yet not suggesting there's a conflict with MBE 2. However, there are at least two reasons why there is nothing inconsistent with concluding that there's a conflict with MBE 9 but not MBE 2. Firstly, the question of quality of design of a proposal is a separate issue to the impact on landscape. Mr. Neeson accepted that his evidence was limited to just consider the question of landscape impact, and should also say visual effects, to be fair, and that the overall question of whether or not the proposal respects local landscape character, i.e. for the purposes of MBE 9 criterion C, involves the further question of design, which was addressed in the evidence of Mr. Pearce on behalf of the appellant. Mr. Noy also agreed with that proposition when asked about it. Were it the case that the question of design is simply the same as landscape impact, then it would necessarily be the case that the scheme has a poor design, as in any analysis, there are moderate adverse impacts on landscape character here, as identified in the TVIA. The council is not suggesting that. Second, and related to the point above, the question of design is considered a separate policy to landscape impact and local plan. But as Mr. Raper explained when questioned on this, MBE 2 is a policy related to conservation and, where possible, enhancement of rural landscapes. That is clear when one looks at the explanatory text that he referred to. Paragraph 231 refers to HARC comprising a high proportion of attractive rural countryside with a range of different landscapes, and also refers to development in the countryside, paragraph 239. This clearly indicates that the policy is focused on those landscapes and not townscapes. I've referred to policy Gen 1 as well, so in my written evidence, but I think that I've already mentioned that above, so I'm not going to read it. Just turning to the detail of the poor design of the scheme, the council's position remains that there's a clear conflict with those development plan policies I've referred to above, and MPF paragraphs 131, 135, and 139. For the reasons set out in Mr. Raper's evidence, he identified several issues with the scheme in his evidence, which I'm set out below. However, before dealing with those in detail, it's clear that the appellant's focus, apparent at least in the questions that were put to him, on Mr. Raper's acceptance of the TVI's conclusions on landscape and visual harm is misplaced. First, it is of course the case that Mr. Raper is not a landscape architect, and he rightly did not take issue with the findings of the appellant's TVIA. But that clearly does not mean that as an experienced planner, he is not entitled to reach his own view as to the impact of the scheme on the character of the area. It is ultimately a question relevant to the question of acceptability of the scheme's design. As Mr. Raper explained, it is entirely usual for planning officers to reach views on such questions, taking into account the technical reports prepared by others and the internal conservation responses of officers within the councils, whether landscape officers or urban designers. Reaching a view on design and the impact and character area is clearly within the expertise of a chartered town planner, just as it's open to you, sir, to reach a view on that question. It is ultimately and quintessentially planning judgment. Second, the TBIA's conclusions are consistent with Mr. Raper's assessment that there would be significant harm to the character of the area. In particular, the TBI clearly identified material impacts on landscape character in the vicinity of the site. It identified minor to moderate long-term, i.e. after 15 years post-development, adverse effects. In terms of visual effects, it also noted that, for example, for users of Elverton Heath Way, again, a minor to moderate adverse effect would occur. Those effects clearly are material in planning terms. Mr. Neeson himself accepted that they were not insignificant. In any event, as Mr. Raper explained, a TBIA is not an assessment of the design and architectural proposal. And as he made clear, it's not an evaluation of the design of the development. However, the TBI also went on to apply a judgment about which effects would be significant in the very specific sense of, and I quote, meriting particular consideration in the planning process. And that was at paragraph 11.61. So the authors of the TBIA, i.e. Mr. Neeson, clearly took the view that only moderate to major adverse was significant in that particular sense. That was Mr. Neeson's judgment. Nothing in the Glivia guidance, for example, prescribes such an approach. But even if his judgment is right, and it is highly open to this inquirer to take a different view, that particular conclusion does not mean that all other effects he identified do not merit any consideration at all in the planning process. The appellant will no doubt stress this particular conclusion in TBIA and the fact that the council did not disagree with the TBIA and the officers of report, nor did Mr. Raper to take any particular issue with it, and argue that it is therefore not open to Mr. Raper to conclude that there be significant effects. If such a point is pursued, it is both highly opportunistic and wrong. It fails to account for the clear distinction between the way Mr. Raper assessed significance as part of his planning judgment on the character of the area, i.e. in the everyday sense of that word, and the very particular and specific sense of the word significant applied by Mr. Neeson at paragraph 11.61 of the TBIA. So just turning in briefly to the specific points of design. Firstly, the blank elevation to the rear of the building. Mr. Raper identified concerns with the rear blank elevation of the proposed building. His evidence sets out how there would be a blank and imposing inactive frontage on the west-facing rear elevation of the building, which would be, in his terms, largely unrelieved, with little in the way of relief or detailing, which gave an industrial appearance to the building. The question of whether this is an appropriate design response has to be considered in the context of this particular site, as design has to consider context, a proposition which the appellant's architects, Mr. Pearce, agreed with. As Mr. Raper explained, the National Design Guide places great emphasis on the importance of context in achieving good design, and context is one of the 10 characteristics of well-designed places. It makes clear that good design starts with understanding the context, responding positively to it. Highly relevant to the question of context is the fact that this would be the first building that someone entering into Elverton Heath would see on the east side of Elverton Heath Way. It clearly forms part of the gateway corridor into Elverton Heath. Whether or not it actually forms part of the gateway entrance is not the key question in splitting hairs. The TBIA acknowledges that it forms part of the gateway corridor. Mr. Neeson and Mr. Pearce both rightly accepted that it was therefore an important location. Yet the appellant's response to this important location is to position a building such that it presents a blank elevation to Elverton Heath Way, and relies on the tree cover and additional screening to hide it. Critically, Mr. Pearce rightly and fairly accepted that absent the tree cover and additional planting, this would not be an appropriate design response. Therefore, the appellant's case over the acceptability of the design, the blank elevation in particular, rests entirely on the premise that it will be screened from view. That premise is flawed. The appellant appears to rely on the figures in the TBIA showing a near invisible development from this particular part of Eltham Heath Way. However, both Mr. Pearce and Mr. Neeson agreed that the evaluation will not be completely screened, clearly will be visible, particularly in winter when whatever retained or new trees that are planted will be leafless. This is precisely why in the TVIA it identified that there was a moderate adverse visual impact to visual receptors on Elverton Heath Way. Mr. Raper also explained it would be visible to people walking along Elverton Heath Way, that they will not merely experience the scheme from one point. In summary, the concerns of Mr. Raper regarding the inappropriate design of the building and this particular blank elevation are entirely justified. Second main group of concerns, the failure to take into account the form of other civic buildings in the local centre of Elverton Heath. Mr. Raper's concern in essence in this regard was that the proposed store appears to be a standardised corporate design rather than one that would be genuinely designed to respond to context. As explained in more detail in his oral evidence, the design of the building fails to take any inverted commas cues from the rest of the built form, particularly those in the civic centre. By that I mean the local centre. Those buildings made varying attempts to pick up features of the local rural vernacular, the late 19th century Victorian Edward style, and in particular arts and crafts style, whether in the use of gable end, cat's eye roofs, dormers, etc. Mr. Raper explained that this architectural approach was cohesive in the sense that one can ascertain where there were conscious attempts when Elverton Heath was built to reflect aspects of the rural vernacular, Victorian Edwardian styles, and the arts and crafts style. That the approach reflected what was set out in the Elverton Design Brief in 1999. This, for example, referred under paragraph 3.41 to a coordinated approach to architectural style with an overriding objective to provide varied architecture drawn from 3 local distinctive styles. The Elverton Design Brief does not, of course, constitute supplementary planning guidance, and the council is not suggesting it has to be followed in the same way as the original developers of Elverton Heath had to, but it is material to understanding the design approach taken to the design of the buildings that are present now. Council is also not suggesting some sort of copying or pastiche of those styles should be incorporated into the design of the Lidl building, but it is clear no attempt whatsoever to take any sort of cue from the architectural approaches that has been taken, particularly in the local centre, which is common ground that this proposal will be read together with once built. That sentence bit garbled, so it should say it is clear that no attempt whatsoever has been taken to take any sort of cue from the architectural approaches, which is common ground that this proposal would be read together with once built. So just turning in a bit more detail to the appellant's approach and what Mr. Pearce's evidence states. It's not in dispute that the colonnades, the use of brick and the use of vertical timber, referred to by Mr. Pearce in his evidence, are not features necessarily that can be found in some of the standardised Lidl designs set out in Mr. Raper's evidence. But all of those features, which Mr. Pearce was keen to stress as differentiating factors, are clearly not a response to the context of the rest of the built form of Elverton Heath. They merely attempt to try to elevate the scheme design beyond what Mr. Pearce's own evidence indicates was part of the design development process, i.e. a standard Lidl design template. The use of vertical timber was just one example of where design features are employed which do not draw at all from, or to use Mr. Raper's evidence, take their cue from, the rest of the buildings in the local centre. Of course, the council is not suggesting this feature alone would lead to a finding of poor design as a whole, but its deployment here, in circumstances in which Mr. Pearce was unable to point to its use anywhere else in the immediate area, is symptomatic of the overall design response of the appellant, which appears to consist in a deliberate decision to not echo or take cues from the architectural approach evident in Elverton Heath. Consistent with that, Mr. Pearce's evidence made no reference to the Elverton design brief. There are further reasons why Mr. Pearce's evidence as to the standard of design of the scheme is unconvincing. His written evidence appeared to suggest the building was innovative, but he resolved from that in his evidence. When asked about the instructions given to his firm and they were after to achieve high quality design, he said he did not know. He was asked several times by me about whether he thought the scheme was of high quality. He finally confirmed that it was, but the fact that it took several questions to elicit that answer, and then he did so when asked by you, sir, reduces the weight to be attached to this assertion. The appellant's design approach was set out in the design and access statement. That made no reference to high quality design or to the Elverton design brief in the section on building considerations and design. All of this indicates that the appellant's design approach, based on what its architect, Mr. Pearce, suggests in his evidence, is clearly to assume that in the immediate vicinity of the site, there is a lack of single identifiable typology and is just a collection of individual buildings. And this justifies the introduction of what is clearly a generic design, admittedly with some additions, used in little buildings nationally. The council considers that this was the wrong approach, not least as it does not reflect the local character of the area, and does not acknowledge the role the Elverton design brief played to guide the urban design of the area. So just turning to the impact on trees. In addition to design, the loss of trees is clearly relevant to the question of impact and character of the area. The council is not suggesting there's a policy requirement that all trees have to be retained on site. But the extent of tree loss and the degree to which the appellant's proposed planting scheme will mitigate that is clearly relevant to the question of impact and character of the area. Mr. Raper's evidence is that the predominance of mature trees was a distinctive characteristic of the surrounding area and echo the past historic land uses. He confirmed his oral evidence that the trees within the site, other than those within the hard standing, as shown on his figure 6, are covered by an area-wide TPO. He also confirmed his evidence in his oral evidence that they have significant public community value and they are appreciated, despite the limited public vantage points towards some of the trees. His evidence was that the planting scheme would not adequately compensate for the loss of established and protected trees in terms of scale, maturity, structure, or contribution to the green infrastructure network. The point identified by Mr. Raper about tree maturity is important. In this regard, the appellant's arboricultural expert accepted that there will be a like-for-like replacement in terms of numbers of trees, with 47 lost and 47 replaced, if one takes into account those included as part of the BNG proposals. His analysis was entirely numerical and did not take into account the quality of the trees. 30 of the 47 trees are category B trees, and therefore, in the words of Mr. Cleves himself, are one which a developer would usually seek to retain. Category B trees are rated as trees of moderate quality. The reason those trees are category B reflects their maturity as specimens and therefore their value. It is clear, therefore, that the planting scheme will not be a like-for-like replacement of what is there. There will be a material net loss in terms of quality of the trees that are lost, particularly those in the southern half of the site. All of this is consistent with the findings of the TVIA, which never suggested that mitigation would completely nullify the adverse impacts altogether. To the contrary, it states in terms of the loss of existing trees that this would be partially mitigated by replacement planting. Hence the TVA's finding not that there would be no visual effect at all, in particular for users of Elverton Heath, but rather that under the heading significance of effect, there would be a moderate effect in year 1 and a minor to moderate adverse effect long term, i.e. in year 15. The loss of trees also is relevant to the loss of the part of the green infrastructure which is protected by IMF2. As Mr. Raper explained, the green infrastructure network has a role in maintaining visual amenity, and his concern with the impact of the network with the impact of the scheme on the network was the visual impact caused by its loss. Contrary to what Mr. Moore seems to understand the policy to mean, the policy protects against the loss of the network in absolute terms. It does not just protect against loss of function. If that is what the policy was directed at, it would have said so in terms. There was a good reason for that. If it were read as allowing loss of the network so long as function is not affected, it would result in piecemeal and incremental loss. That simply does not make sense given its purpose as a protective policy. The fact that explanatory text at 341 refers to other significant impacts on the functioning network does not and cannot rewrite the actual wording of the policy. The explanatory text itself makes clear in the preceding paragraph 340 the overall aim of policy INF2 is to protect and enhance the district's green infrastructure network. The proposal is clearly contrary to that aim and contrary to INF2. So in summary, so in light of the poor design of the scheme and the loss of trees, there clearly would be significant harm to the character of the area. Now, in terms of how that relates to conflict with development plan policies, the proposal will therefore conflict with the following policies. Conflict with MBE 9 because it would not seek a high quality design, nor would it positively contribute to the overall appearance of the area, the first limb of MBE 9. Nor would it respect local landscape character because of its poor design and the loss of trees, and it does not sympathetically incorporate on-site landscape features in the form of trees, criterion D. The proposal will therefore also conflict with Con 8 because new planting does not maintain the value of those features, and it would conflict with Gen 1 because the proposal is not in keeping with local character by virtue of its design and landscape. It would also conflict with INF2 because of the loss of the network, the green infrastructure network. So just turning finally to the benefits of the scheme. In terms of the benefits of the scheme advanced by the appellant and the weight to be attributed to them, there's not a significant difference between the parties in relation to those benefits. The council agrees significant weight should be attributed to the utilisation of the site that is PDL, previously developed land. The council agrees that significant weight should be attributed to the creation of 40 new job opportunities, but only limited weight should be attached to the support to construction jobs. Only very limited weight should be attached to improve consumer choice and competition. No particular need has been identified by the appellant for a new store in this location. Moderate weight can and should be attributed to the delivery of in excess of 90% biodiversity net gain. Mr. Raper agreed that the entirety of the biodiversity net gain being offered should be taken into account, but as he explained, 10% BAG is a statutory requirement. Mr. Raper also attached moderate weight to the encouragement of sustainable shopping patterns. He explained that the highway improvement, i.e. the extension of and widening of the cycle and pedestrian pathway, was only of some incidental benefit and is neutral in terms of weighting. This is because ultimately it was required to make the scheme acceptable in highway terms. And in terms of the benefits suggested that will be delivered to Lidl's community engagement and support for local charities, as Mr. Raper explained, no particular weight should be attached to that. So in terms of the planning balance, conflict with the development plan as a whole, the key question is whether there is a conflict with the plan as a whole. Unlike Mr. Moyer, as part of that analysis, Mr. Raper looked carefully at consistency with each policy referred to in the reasons for refusal, and concluded rightly that full weight should be attached to Gen 1, MBE 9, INF2, and ED4. There's also conflict with the Con 8, albeit less weight could be attached to that, given to the degree of inconsistency with the MPPF, which Mr. Raper fairly acknowledged. But in summary, in light of the harm to Fleet Town Centre and the poor design and in detrimental impacts on character in the area, there is clear conflict with each of these policies because their requirements are not met, and clear conflict with the development plan as a whole. The fact that a policy contains a number of requirements does not mean that only if one of those requirements are met, there is only partial. Does not mean that only if one of those requirements are not met, there is only partial conflict with that policy. If in that sense it's suggested that this affects the weight to be attached to that conflict. Mr. Raper rightly attached significant weight to the retail harm identified by Ms. Reeves and the harm to the character of the area that the proposal would cause. This is not least as if there is also clear conflict with the NPPF key policies on design, particularly 131 and its reference to the creation of high quality buildings. I should say this is not least as there is also clear conflict with the key policies on design, in particular paragraph 131 and its reference to the creation of high quality buildings, and paragraphs 135 and 139. The latter states that development which is not well designed should be refused. There is also clear conflict with the NPPF policy on retail impact. Significant weight can and should therefore be attributed to the clear conflict with the development plan as a whole. Just turning finally to other material considerations, just addressing the appellant's new case that the tilted balance under paragraph 11D should be engaged. The appellant's contention advanced for the first time in Mr. Moyer's proof of evidence at paragraph 8.2 that the tilted balance under 11D of the NPPF should be engaged on the basis that the Hart local plan was out of date due to a lack of review of the Hart local plan. It's plainly misconceived. Mr. Moyer was simply wrong as a matter of fact, but there's no review. There has been a review, as Mr. Raper explained as rebuttal. The appellant's new contention suggested in cross-examination Mr. Raper and actually advanced for the first time in Mr. Moyer's oral evidence that the tilted balance should be engaged because the policies most important for determining the appeal are out of date due to inconsistency with the NPPF is again plainly wrong. Notwithstanding that this did not form part of the appellant's case, the fact that there is a degree of inconsistency between Save Policy Con 8 with the NPPF, para 136, which Mr. Raper accepted entirely reasonably to his credit, and so far as it requires all trees to be retained, does not mean that the policies most important for determining the application are out of date. That involves consideration of the key policies on design, NBE9, and the key policy on retail impact, ED4. It's not suggested there's any inconsistency with the NPPF at all in relation to those policies. In relation to INF2, that policy is also clearly consistent with the NPPF. Mr. Moyer suggests in cross-examination, again, this is the first time there's any suggestion that this was a point the appellant was going to advance, that INF2 and its protection of the network identified by the council conflicted with paragraph 188 and its reference to plans should take a strategic approach to maintaining and enhancing networks of habitats and green infrastructure. Setting aside the fact that this policy relates to what approach plans should take and not decision making, the short point is that there is absolutely no consistency between a policy which identified a green infrastructure network and protects against its loss, and a strategic approach to maintaining and enhancing a network of habitats and green infrastructure. Protecting a green infrastructure network is entirely consistent with maintaining and enhancing that network. In case there's any doubt over this, Mr. Raper's adduced various appeal decisions in which INF2 was considered, and in none of these did any inspector identify any inconsistency between INF2 and the NPPF. It's still not known what the appellant's precise or actual case is regarding the weight to be attached to these appeal decisions because it's never formed part of its case. But even if it is the case that that particular cases put to the inspectors by the parties is not known, or that it was a specific issue in the determination, or it was not a specific determination in the determination of those appeals, that does not mean that this inquiry is not entitled to place weight on the fact that in several appeal decisions, no issue has been identified by any previous inspector with inconsistency of ENF1 with the NPPF. To report, just finally, in terms of scheme benefits, as Mr. Raper explained in answers put to him in cross-examination, it's not the case that on a flat balance, the benefits outweigh the harm, merely because those benefits are more numerous. Nor is it the case that merely because he attached significant weight to those harms and significant weight to the main benefits of the scheme, that the balance falls in favour of permission. As he explained, the attribution of significant weight entails a spectrum, and he was clear that the scales still come down in favour of refusal. Mr. Raper was also clear, rightly, that those scales still come down in favour of refusal, even if the inspector disagrees with the council's case on retail impact. So just summing up on the ultimate balance, the balance under 38(6), Planning Compulsory Purchase Act 2004, the question of weight is ultimately a matter for USER to determine. But if USER reached the same conclusion as Mr. Raper in terms of the degree of retail impact and harm to the character of the area and the poor design of the scheme, then it is equally open to USER to reach the view that there are no material considerations which outweigh the conflict of the development plan as a whole, and that therefore, pursuant to section 38(6), permission should be refused. In summary, therefore, for the reasons set out above, permission should be refused, and the council would respectfully invite USER to dismiss the appeal. Those are my closing submissions on behalf of the council.
Thank you, Mr. Neal. All noted and understood. Thank you for those contributions. I'll now invite Ms. Sargent to make her closing submissions, please.
Thank you, sir. Could I just have 30 seconds? I've been editing my draft as Mr. Neal's been speaking, so if I could just have 30 seconds to finish a paragraph and then send the document through, that would be very helpful.
That's absolutely fine, yes.
Thank you. Right, thank you, sir. I'll just email the PDF to Mr. Neal and also to Mr. Moyer so that he can send it on to you.
Okay.
Thank you, sir. So I've made some of the responses that I need to make to Mr. Neal's closing in the document. There are some points that I'll have to just respond to orally at the end, if that's okay with you, but I'll make sure that you're able, obviously, to take a proper note of what I say.
Yes, please go ahead.
Thank you, sir. So at the end of the inquiry, this appeal has arrived at an unusual conclusion, which is that on the council's own case, the benefits that the scheme will deliver outweigh its harmful effects. Mr. Raper's dogged refusal to accept that this was so was not remotely persuasive. He gives significant weight to two benefits, the first being the economic benefits of the scheme's job creation, and the second being the benefit of bringing an appeal site that is PDL into productive use. He gives moderate weight to two further benefits, the first being the scheme's BNG, which would be in excess of 19%, and the second being the encouragement that the scheme will give to sustainable shopping patterns, making a positive contribution to the health and social well-being of the community. Finally, Mr. Raper acknowledged that if the appellant's retail evidence is preferred, some, albeit in his view very limited, weight attaches to the scheme's contribution to consumer choice, and he also acknowledges some incidental benefit from the provision of the cycle path. Now, even discounting the consumer choice and the cycle path points, and including only the two significant and the two moderate benefits in the overall planning balance, the positive side of that balance obviously outweighs the negative side, into which, even if the council's case is accepted in its entirety, Mr. Raper puts only retail impact and harm to the character of the area, with both adverse effects being given significant weight. The appellant's position is that Mr. Raper continues to undervalue the scheme's benefits. As Mr. Moyer explained, moderate weight should be given to the construction jobs, and that's in addition to the significant weight given to the jobs created in the store itself. Significant weight, not moderate, should attach to the BNG in excess of 19%, particularly given that the provision will be made on-site and not in some alternative location remote from the appeal site. Moderate weight should be given to the consumer choice aspect, given where Lidl sits in the market in terms of price point in an ongoing cost of living crisis, and significant weight should go to the provision of the cycle lane too. And in response to paragraph 78C of the council's closing, it's regrettable, we say, that in contending that only very limited weight should be attached to improved consumer choice and competition, because the council says no particular need has been identified by the appellant for a new store in this location, the council entirely fails to recognise the specific benefit of a discount rate retailer entering the market in the context of a cost of living crisis. The appellant also remains very firmly of the view that the alleged adverse effects identified by the council have been very considerably overstated, and the analysis that I'll come to explains how that has happened. But even if you, sir, don't agree with the appellant on either of the above points, an air of unreality pervades Mr. Raper's insistence that on his own case, 2 + 2, so two significant benefits and 2 moderate benefits, is somehow outweighed by 2 alone, i.e. by 2 significant adverse effects. Still further divorced from reality was Mr. Raper's refusal to accept that if only one significant harm, so either retail or character, were ultimately identified, the benefits of the scheme would, in that scenario, then outweigh the singular harm. And this isn't an overly numerical point, as Mr. Raper suggested. The point made fully reflects not only the number of benefits against the number of harms identified by Mr. Raper, but also the weight that he attaches to all of them. So in the appellant's submission on the council's own evidence, the benefits of the scheme plainly outweigh its harm, and this is a very powerful material consideration in favour of granting planning permission. The remainder of these submissions will focus on the alleged adverse effects identified by the council. That doesn't indicate that there's any merit in the council's case. It simply reflects the fact that, as is typical at a planning inquiry where the focus is on the local planning authority's reason or reasons for refusal, there has been much discussion of the alleged adverse effects of the scheme and comparatively little discussion of its benefits. Turning to the first reason for refusal and retail impact, if you're satisfied, sir, having now read and heard all of the evidence in this appeal, that it is not likely that Fleet Waitrose will close as a result of the impact of the scheme, then the first reason for refusal must be dismissed. The only basis on which the council contends that the scheme would have a significant adverse impact on the vitality and viability of Fleet Town Centre, and it's common ground that that is the applicable policy test, is that the council argues that the scheme is likely to result in the closure of Fleet Waitrose. The council now contends that the closure of that store alone would amount to a significant adverse impact against a baseline that the parties agree no longer includes Fleet M&S. The key points of dispute between Ms. Reeves and Mr. Singer are first, the extent to which Mr. Singer's analysis has, on Ms. Reeves' account, overestimated the performance of Fleet M&S. Secondly, the extent to which Mr. Singer's analysis has, again, on Ms. Reeves' account, underestimated the performance of Fleet Waitrose. Thirdly, the percentage of trade diversion that will result from Fleet Waitrose to the scheme. And fourthly, the percentage of trade that will be redistributed now from Fleet M&S to Fleet Waitrose following the closure of the M&S this summer. The short answer to the entirety of the council's case on retail is that even if the scheme's impact is analysed on the basis for which the council contends, save as regards the trade diversion figure, as to which we say that the figure put forward by Waitrose itself properly indicates the worst case scenario position, the outcome of that analysis does not evidence any realistic prospect of Fleet Waitrose closing as a result of the scheme. Still less is there any evidence of a likelihood of closure, which of course is the policy test. And I'll come on to explain that contention in detail, but before I turn to those submissions, the appellant makes the following preliminary observations. Ms Reeves contends for different inputs, in particular for Fleet M&S's overperformance, for Fleet Waitrose's underperformance, for trade diversion from the Waitrose to the scheme, and for redistribution of trade to the Waitrose once Fleet M&S closes. And she does so primarily because she criticises the results of the NEMS household survey. It was, with respect, impossible to reconcile Ms Reeves' sustained criticism of the survey with her clear statement at paras 115 and 116 of her proof and confirmed in her cross-examination that whilst she had a number of ongoing concerns regarding the household survey, nevertheless, in the light of the submission of the NRIAA, there is now an adequate retail impact assessment available for the purposes of paragraph 94 of the NPPF, and an assessment of the significance of the impact of the appeal proposal on the vitality and viability of Fleet Town Centre can be undertaken, albeit, she says in her proof, she disagrees with several of the professional judgments contained within it. But in any event, Ms Reeves' criticisms of the survey ultimately take the council nowhere, since even if alternative inputs to those utilised by Mr Singer are preferred, for example, the unweighted figure of 64% against company average benchmark for the Waitrose's performance, which Ms Reeves put forward, the analysis demonstrates that there is still no likelihood of Fleet Waitrose closing as a result of the scheme. Ms Reeves doesn't agree with Mr Singer's reliance on a turnover for Fleet M&S that equates to 880% of the M&S company average. I'm going to refer to the company averages as the benchmark. Mr Singer has, though, repeatedly made clear that it's not his evidence, nor is it the appellant's case, that the M&S in Fleet is trading at 880% against the benchmark. As he explains in his proof at 615, in practice, the level of turnover identified for the M&S at 8.5 times the company average levels in the UK, and for Sainsbury's 4 times company average levels, may be an overestimation, having captured more of these shoppers on this particular occasion. Equally, the turnover identified for Waitrose may be an underrepresentation. And he goes on to say at 616, however, collectively across the town centre, the extent of any of these potential discrepancies is diluted as the number of answers and responses increases, providing a more statistically robust data set and a clearer picture of the directional trend, that is, that the 3 main food stores across Fleet are collectively overtrading by 2.5 times the company averages. In cross-examination, Mr Singer confirmed that he agreed with paragraph 3.9 of the appellant's statement of case, which notes that the survey results are very likely to be a significant overestimation, and he clarified that the 880% figure was an aide-memoire to determining the application. You won't, he said, find a retail consultant who will sit up here and say these are precise figures. The council appeared to criticise Mr Singer in the first cross-examination, first of all for not having made a manual adjustment to the turnover figure for Fleet M&S, and secondly, for not having explained in his proof why he had not done so. And as you've just heard, sir, the council maintains that criticism in its closing. Excuse me. This criticism was and is entirely unfair. At no point prior to the first cross-examination of Mr Singer had the council ever suggested to the appellant or to its consultant team that a manual adjustment ought to be made. No such suggestion was ever made during the application stage, nor was any such suggestion made by Ms Reeves in either her written or her oral evidence, and that's despite the fact that I asked her expressly and specifically what she said the solution was to the alleged unreliability of the survey. Should the council maintain this criticism of Mr Singer in its closing submissions, which we've heard it now has, that criticism is completely unsupported by the evidence of the council's own witness, and it should be disregarded entirely. Ms Reeves, in re-examination, invited you to prefer the unweighted figure of 64% against benchmark for the turnover of Fleet Waitrose, in preference to the weighted figure of 58%. The appellant fundamentally disagrees with Ms. Reeves' stance on this point. Mr. Singer was obviously correct to observe that the appropriate response to concerns in respect of the weighting exercise is not simply to revert to the unweighted survey results, which are recognised as being unrepresentative, hence, of course, the need to undertake the weighting exercise in the first place. Next, Ms. Reeves sought to resurrect her concern in relation to questions 7 and 11 of the survey yesterday, in the evidence session that was supposed to address only the new material consideration of the impending closure of Fleet M&S. Mr. Singer was right to identify that this was merely a distraction. If there were any substance to the point, it would and should have been identified by Ms. Reeves in her evidence last week, during the course of which I asked her to confirm what the significant points of dispute with Mr. Singer were, and this point on questions 7 and 11 was not identified as one of those significant points. Mr. Singer has previously addressed the issue in his email to the Council of the 7th of May of this year, and he explained in his evidence in chief that it arose because Ms. Reeves has continued to use the PDF of figures that she was provided with in August 2024 and not the Excel version from May this year. Mr. Singer's unchallenged evidence was that the point didn't change anything in the overall analysis. Ms. Reeves didn't set out any proper analysis or response to Mr. Singer's analysis in her written evidence. That evidence does not identify a figure or even a looser range within which an alternative figure is identified as falling for key inputs to the retail impact analysis, including an alternative turnover figure for the Fleet M&S, an alternative turnover figure for Fleet Waitrose, an alternative trade diversion figure or percentage for the diversion from the Waitrose to the scheme, and a figure or percentage for the trade redistribution that will now happen from M&S to Fleet Waitrose following the closure of the Fleet M&S. Her approach is at odds with both with that of Mr. Singer and also with that of First Plan on behalf of Waitrose, who do identify alternative figures. Whilst Ms. Reeves claimed to have decided against identifying specific figures or ranges of figures because, in her view, the role of Fleet Waitrose in the town centre was of such significance, that is a patently bad justification for the approach taken. The assumption made as to the significance of Fleet Waitrose entirely preempts the outcome of the analysis that provision of figures or ranges of figures would inform and illuminate. It is to put the cart very obviously before the horse. The council suggested to Mr. Singer that certain points made in his oral evidence were not found in his written evidence, and I add that a similar criticism has been made of some of Mr. Moyer's evidence. This was very hypocritical, given the extent to which Ms. Reeves introduced new points for the first time in her oral evidence, including the suggestion of the 200% against benchmark for the Fleet M&S turnover, the 64% against benchmark figure for unweighted Fleet Waitrose turnover, the figure of a further 1 to 2 million for trade diversion from Fleet Waitrose to the scheme, and the 20% figure for redistribution of Fleet M&S trade to Fleet Waitrose. So moving on from those preliminary observations to the detail of the points that are in dispute between Mr. Singer and Ms. Reeves, it's common ground, as I mentioned, that the baseline against which the impact of the scheme now falls to be assessed no longer includes the Fleet M&S, following the announcement last week by M&S that the store will close in August. The council persisted in arguing yesterday that Mr. Singer's reference to a turnover for Fleet M&S that equates to 80% of the benchmark was misplaced, and asserted that Mr. Singer's scenario 3 and 4 in his addendum sent in on Monday were in consequence flawed. The latter assertion is obviously incorrect because, of course, scenarios 3 and 4 in what I'm calling the June addendum, so the Monday addendum, present the position on the basis that Fleet M&S has no turnover at all because it's closed. Even if the council were previously justified in criticising Mr. Singer's reference to the 880% turnover, which for the avoidance of doubt we don't accept, that criticism can't attach to scenarios 3 and 4. Those scenarios aren't vitiated by a reliance on an M&S fleet turnover of 880% as opposed to the 200% against benchmark for which Ms. Reeves ultimately contended yesterday, because they reflect the position following the Fleet M&S closure. So they reflect a position in which the Fleet M&S turnover is 0. The council was therefore wrong to argue that the possibility of the design year turnover of Fleet M&S being 200% rather than 880% against benchmark was directly relevant to or might affect Mr. Singer's analysis in his scenarios 3 and 4. The only other point in dispute between the parties on scenarios 3 and 4 is what percentage of Fleet M&S's current trade should be redistributed in the analysis to Fleet Waitrose. Ms. Reeves and Mr. Singer agree that it's appropriate to assume that up to 40% of the current spending at Fleet M&S will be redistributed outside of Fleet Town Centre, and that an additional 20% will be redistributed to other M&S stores beyond Fleet. Of the 40% of Fleet M&S's current trade that remains to be redistributed in the analysis, Mr. Singer's view is that 30% will be redistributed to the Waitrose and 10% to the Sainsbury's. Ms. Reeves contends that the split will be 20 to Waitrose and 20 to Fleet to the Sainsbury's, so for an even split. Mr. Singer's view should be preferred for the reasons that I'll come on to. But even if Ms. Reeves is correct to contend that only 20% of the Fleet M&S's trade will be redistributed to the Waitrose, there would still be no, or at most very little, likelihood of the Waitrose closing as a result of the scheme. Indeed, and to the contrary, Mr. Singer is plainly correct to conclude that following the closure of Fleet M&S, Fleet Waitrose will, in all likelihood, be doing better than it is at present. Scenario 3 in Monday's addendum develops Scenario 1 to show the post-Fleet M&S closure position, and it reflects Table 14 within Appendix 3 to Mr. Singer's rebuttal, which, as he explained last week, is the up-to-date and accurate version of the document that was originally submitted in error as Appendix 3 to the NRIAA. Scenarios 1 and 3 assume that 1.5% of the scheme's trade will be diverted to the scheme from the Waitrose, and they also assume a design year turnover for the Waitrose of 58% against benchmark. First Plan, on behalf of Waitrose, contend that a higher trade diversion figure from the Waitrose to the scheme should be assumed of 10% of the scheme's trade going to the scheme from the Waitrose. Ms. Reeves has never provided an alternative percentage figure, but she suggested that there would be a further 1 to 2 million. That suggestion is simply not credible. As Mr. Singer noted in response, it equates to a range of 12.8% to 24.2%, which is well above even the 10% that Waitrose itself argues will be diverted from its Fleet store to the scheme. On the Waitrose's performance against benchmark, Ms. Reeves invited you to prefer the unweighted figure of 64% and not Mr. Singer's weighted figure of 58%. Now, Mr. Singer doesn't consider that alternative scenario to be well-founded, but he has analysed it along with the First Plan 10% trade diversion figure as scenarios 2 and 4 in his addendum from Monday. Where we get to is that even if scenario 4 is preferred over scenario 3 as an analysis of the post-Fleet M&S world, so even if we take the First Plan trade diversion figure and the 64% performance against benchmark figure from Ms. Reeves, it's plain that the Fleet Waitrose will not close as a result of the scheme, even if Ms. Reeves were correct to argue that only 20% and not 30% of the M&S's turnover will be redistributed to the Waitrose. In scenario 4, as a result of the closure of the M&S, the performance of the Waitrose improves from 64% to 99% against benchmark. Once commitments and the scheme are taken into account, that performance reduces to 90% against benchmark. 90% of benchmark is a turnover of 14.66 million. Ms. Reeves' position is that the Waitrose is currently trading at 64% of benchmark, so at 10.41 million. Therefore, an additional £4.25 million of trade could be diverted from Fleet Waitrose by the scheme, so that's 4.25 million on top of the 1.01 million that scenario 4's already assumed, and the Fleet Waitrose would still trade at 64% of benchmark, on which basis it is, on Ms. Reeves' own case, continuing to trade at present. So in the post-closure of Fleet M&S world that's being analysed as scenario 4, the scheme would have to divert more than an additional £4.25 million of trade, and again that's on top of the £1.01 million that's already identified as being diverted, to take the performance of Fleet Waitrose beneath the 64% at which it currently continues to trade. And then there's a rogue reference there to a 4.15 million figure, so that should be 4.25 million. That figure equates to 48% of the scheme's turnover of £8.8 million. Now, even Miss Reeves does not contend that trade diversion from Fleet Waitrose to the scheme will be as high as 48%. The highest figure that results from her evidence is 24.2%. It's simply not credible for the council to suggest that if scenario 4 were amended to reflect redistribution of only 20% of the M&S turnover to Waitrose and not 30%, this scenario might then evidence a risk of Fleet Waitrose closing. Even on Mr. Singer's turnover figure for the M&S, which is the 18.74 million figure that Ms. Reeves says is too high, the difference between the 30% and the 20% turnover figure is only 1.87 million. The council is in effect arguing that if the figures given in scenario 4 in columns A to C for the Waitrose turnover, which range from 14.66 to 16.03 million, were reduced to reflect the difference between the 30% and the 20%, and that reduction would involve, on any evidence, a maximum reduction of 1.87 million, the result would somehow be a turnover for the Waitrose of under 10.41 million. That argument is obviously wrong. As to the reasons why Mr. Singer's figure of 30% for the redistribution of the M&S trade to the Waitrose should be preferred, Ms. Reeves in her addendum states at paragraph 13 that Sainsbury's will see the greatest benefit given its location next to the Simply Food unit, which will make it the most convenient alternative. But she changed her position in oral evidence to argue that the Sainsbury's and the Waitrose will see equal benefit. In addition to the shifting position, it's notable that the only reason given by Ms. Reeves in her addendum for the Sainsbury's seeing particular benefit is store locational proximity to the M&S. That point is weak, given that the Sainsbury's and the Waitrose are merely a couple of 100 metres apart. Mr. Singer's 30% reflects the survey data on the extent to which the M&S, Sainsbury's and Waitrose cater respectively to top-up trips as opposed to main food trips. He was right to point out that both the weighted and the unweighted survey results show very similar ratios. Those ratios support his 30% figure and not Ms. Reeves' 20% figure. M&S and Waitrose are also more similar than are M&S and Sainsbury's in terms of price point. Ms. Reeves agreed that. And Mr. Singer was obviously correct to observe that M&S and Waitrose both operate at the premium end of the market. Sainsbury's is less likely to be frequented by workers in Fleet seeking a premium offering by way of top-up shop on their way home. Excuse me. Returning for completeness to the 200% turnover against benchmark figure suggested by Ms. Reeves for Fleet M&S yesterday, as already explained, the council was wrong to argue that the possibility of that figure being 200% rather than 880% against benchmark was directly relevant to or might affect Mr. Singer's analysis in scenarios 3 and 4. Excuse me. However, even if Ms. Reeves were correct to contend that the turnover should be 200% and not 880%, the analysis again would not support the council's argument that the scheme is likely to result in the closure of the Fleet Waitrose. As Mr. Singer explained in his cross-examination yesterday, the 680% of turnover that Ms. Reeves says Mr. Singer has unjustifiably credited to the M&S can't be deleted from the analysis of the scheme's likely impact on town centre trading. The turnover figures result from an analysis that begins by looking at how much each person within the catchment spends per year. There's no dispute over the amount of spend within the catchment. The dispute between Ms. Reeves and Mr. Singer is simply as to where that spend goes, so which stores does it go to. Mr. Singer was correct to identify that the council's contention that the disputed 680% of turnover should be deleted altogether from the analysis was in effect a suggestion that a number of people should be deleted from the analysis, and that suggestion is wrong. The appropriate response, should you conclude, sir, that Ms. Reeves' 200% should be preferred over the 880%, would be to redistribute the disputed 680% within the analysis. It's common ground that the appropriate assumption as regards the redistribution of the M&S turnover is that 60% goes outside of the town centre and 40% is retained in the town centre and then split between the Waitrose and the Sainsbury's. As I've discussed Ms Reeves and Mr Singer don't agree on whether the final split of that should be 2020 or 3010. The 680% that's in dispute equates to 14.5 million. That's the difference between Mr Singer's figure of 18.74 million and the figure that Ms Reeve gave us yesterday in her cross-examination of 4.24 million, which is 2 times the M&S benchmark of 2.12 million. But even if Ms Reeves' favoured 20% is taken for the percentage of that 14.5 million that should be redistributed from the M&S to the Waitrose, that improves the Waitrose's turnover by £2.9 million. The council could not have made clearer that Ms Reeves had approached her analysis on the basis that the disputed £14.5 million of M&S turnover doesn't exist in the first place. That was how the question was put to Mr Singer yesterday. That was the wrong approach, as I've explained. To remedy that error in Ms Reeves' analysis, at least £2.9 million should be added to the figure of £11.86 million for the Waitrose turnover that Ms Reeves relies upon. That gives us a revised turnover for the Waitrose of 14.76 million, which is 91% of the average company benchmark for Waitrose. In short, sir, the point is that it would be obviously wrong for you to prefer Ms Reeves 200% without acknowledging that the £14.5 million of town centre turnover that's disputed needs to be redistributed in the analysis, not simply deleted from it altogether, and without also considering what that revised analysis, including the redistribution of the £14.5 million, indicates. The answer to the latter point is that it indicates that the Waitrose is currently trading at 91% of the company benchmark and not at 64%, as Ms Reeves contends. The position if the Waitrose is currently trading at 91% of company benchmark is evidenced in Mr Singer's scenarios 3 and 4, which I've discussed, because those address performance at 89% and 90% of benchmark respectively. Mr Singer's obviously correct to conclude that if the situation is that the Waitrose is currently trading at around 91% of the benchmark, it would face no realistic prospect of closure as a result of the scheme. In short, given that it's now common ground that the Waitrose will receive at least 20% of the M&S trade after August this year, and we say it's 30%, there's no realistic prospect of Waitrose closing as a result of the scheme. Assuming, for the sake of analysis, that the scheme were to cause Fleet Waitrose to close, the council is of course wrong to suggest that the scheme would, in that situation, be responsible for the closure of two of Fleet Town Centre's 3 anchor stores, because it's common ground that the baseline against which the scheme's impact falls to be considered now excludes the Fleet M&S. It's not accepted that if Waitrose were to close, that would result in a significant adverse impact on the vitality and viability of Fleet Town Centre in the post-Fleet M&S closure world. Ms Reeves' evidence was that the Fleet M&S unit is one of the better units in the town centre and probably will be reoccupied. There's clearly potential for a new convenience retailer such as Tesco to enter the market. Moreover, it is at least conceivable that if the Waitrose were to close, M&S would move into that unit. Ms Reeves did not suggest in her evidence that the prospect of M&S moving into the Waitrose unit was inconceivable. Her only point was that M&S had not moved into the former M&Co unit when that had been vacant. But the former M&Co unit is a different prospect to the Waitrose unit. The Waitrose unit was specifically designed for convenience retail, and Mr Singer's evidence was that when it had been available, the council had agreed that the M&Co unit had not been sequentially preferable. Secondly, the evidence of M&S itself is that it is keen to find a larger alternative location in Fleet in future. As Mr Singer noted, planning policy will steer M&S in that search to the town centre in the first instance. It's common ground that the Waitrose store in Fleet is within 100 square metres of the size of the very recently opened Farnham M&S. So in the light of those points, it's not accepted that the closure of the Waitrose would be likely to result in the closure of the Hart Shopping Centre in its entirety. In addition to the preceding points, the appellant notes that the other anchor unit in the shopping centre, the former M&Co unit, was vacant in July last year but has since been occupied. Food shopping is the second most important reason given by respondents to the survey for going to the town centre, with non-food shopping being the first. Food and beverage and services are also identified as the most important reason by a proportion of respondents. The shopping centre has a range of occupiers, including non-food retailers, food and beverage retailers, and service providers. Ms. Reeves described Fleet as a town centre of two parts. She acknowledged that the town centre outside of the shopping centre is healthy. She also accepted that the shopping centre was built in the heyday of in-person pre-internet shopping, that the result of national retailers such as New Look and Game having gone under, rather than the result of trade diversion to new stores, and she accepted that the shopping centre is contributing less to the vitality and viability of the town centre as a whole now than it would have done in its pomp. Overall, the evidence of Mr. Singer should be preferred to that of Ms. Reeves, whose responses in oral evidence were at times obviously unconvincing. Perhaps the most obvious example of that is her insistence that even if the scheme's impact were only 1.7%, as per Mr. Singer's scenario 3, that would still give rise to a risk, albeit not actually a likelihood, of a significant adverse impact on the vitality and viability of the town centre. Mr. Singer's analysis also accords with simple common sense. If one asks oneself whether the scheme is likely to have a significant adverse impact on the vitality and viability of the town centre as a whole, whilst walking along Healthy Fleet Road and noting the range of independent retailers, national service providers, national food and beverage chains, and also the limited contribution that the shopping centre makes to the town centre's health, having been identified more than a decade ago as lacking prominence and visibility and as potentially requiring development, the common sense answer to the question whether the scheme is likely to have a significant adverse impact is no. I turn then to reasons for refusal 2 and 3, so to design, character and appearance and trees. The council's case on those matters is not compelling, as demonstrated, for example, by the suggestion made for the first time to Mr. Pearce in cross-examination that the use of vertical timber cladding would not be characteristic of Althetham Heath, a point which was not even subsequently supported by the council's own witness, and also demonstrated by the suggestion put to Mr. Pearce, again in cross-examination, that if one assumed a world in which there's no trees or screening at all, then the scheme's west or rear elevation would not be an appropriate design response. As Mr. Pearce noted, such a world is fictional. There's no evidence, and nor indeed is it part of the council's case even now, to suggest that there's any prospect at all of the trees or screening being removed. And the points made on the TVIA at paragraph 56 of the council's closing don't assist the council. As already explained, absolutely nothing, sorry, that says already explained, it's actually a point I'm coming on to, but absolutely nothing in the TVIA supports the council's ultimate argument that the scheme would cause significant harm to the character of the area. The evidence of Mr. Pearce on design matters should be preferred to that of Mr. Raper. Unlike Mr. Pearce, Mr. Raper has no formal qualifications in design or architecture, nor indeed in landscape nor arboriculture. He does not spend his time assessing the baseline and context of a site, its constraints and opportunities, and working out what design response would appropriately respond to those considerations. Moreover, whereas Mr. Pearce leads the retail team at SMR Architects and has significant experience of retail design, including specifically supermarket design, Mr. Raper hasn't previously dealt with an application for a new supermarket from any retailer. Indeed, Mr. Raper's oral evidence betrayed a fundamental misunderstanding of the concept of good design. He was adamant that design must always pick up on its surroundings through roof form, layout, and so on, and must take cues from surrounding built form. There is no such requirement in either policy or guidance. And that's a complete answer to paragraph 63 of the council's closing, and the suggestion that the overall design response here reflects a deliberate decision to not echo or take cues from the architectural approach evidenced in Althetham Heath. There's absolutely nothing objectionable to that approach in policy or guidance terms. Moreover, Mr. Raper's position is simply incorrect. If he were right, and the position is that design must always take cues from surrounding built form, many of the nation's most architecturally fated buildings, plenty of which don't take any cues from the surrounding built form, but rather reflect a deliberate decision to depart from that, would be poor design. Turning to the substance of the main issue, there are three components: design, character and appearance, and trees. Dealing with character and appearance first, in reality, there's actually no justification at all for refusing planning permission on this ground. The landscape character and visual effects of the scheme as recorded in the TVIA are agreed. Adverse residual landscape character effects would be of minor significance on the neighbourhood area as a whole and minor moderate in the vicinity of the appeal site. Visual effects would reduce by year 15 to moderate and moderate minor locally and to negligible elsewhere. It's common ground that the scheme would not give rise to any effects on landscape or visual receptors that are significant as defined by the TVIA, i.e. significant so as to merit particular consideration in the planning process. And I do confirm that it is not, and it never has been, part of the appellant's case that landscape character and visual effects that aren't significant as defined by the TVIA don't merit any consideration at all in the determination of this appeal. In terms of development plan policy relating to landscape character effects, Mr. Raper conceded that the scheme won't give rise to any landscape character impacts that are sufficiently material as to result in any degree of conflict with the Council's primary landscape policy, which is MBE 2, and which the Council doesn't suggest the scheme would conflict with. Turning then to design, Mr. Raper explained in his oral evidence that notwithstanding the agreed conclusions of the TVIA on landscape character and visual effects, he had ultimately arrived at a conclusion in his proof of significant harm to the character and appearance of the area by applying a planning judgment. That analytical step, which is in reality more accurately described as a jump and indeed a large jump, is nowhere described in Mr. Raper's proof. And so, sir, in response to the suggestion from Mr. Neal that this point's an opportunistic one, it's not at all, because the narrative to explain Mr. Raper's approach actually only emerged finally in response to one of your questions in his second cross-examination on planning matters. So I don't accept what's been said about opportunism. Mr. Moyer was correct to observe that there's no evidential basis before this inquiry that would allow such a jump to be made. Mr. Raper eventually explained that he'd made the jump because of his concerns over the design of the scheme, but those concerns aren't made out, as I'll come on to. Mr. Raper accepted that the weight to be given to any design harm, and we say there is none, should reflect the extent to which any such harm has consequences in landscape character and visual terms. Ultimately, even if there were design harm here, and we say there's not, given that the conclusions of the TVIA are agreed and that the Council doesn't allege conflict with policy MBE 2, it can't be suggested that there are any material consequences in landscape character and visual terms. But Mr. Raper's jump from not significant in TVIA terms to significant harm does not reflect his acceptance of this point. Mr. Raper's oral evidence was that he would never rely on an LVIA or TVIA to assess the character impacts of a proposal. This is frankly astonishing and calls into question the utility of the Council requiring applicants to expend time and resources on the production of such documents if they're not to be relied upon for their chief purpose, even where their conclusions are agreed, as here. Mr. Raper accepted that he hadn't taken such an offhand approach to the retail impact assessment work provided by Ms. Reeves, and he also accepted that he wouldn't advise his committee members that a noise impact was significant if he had two noise reports in front of him, both concluding that it was not. His explanation was that the Council's landscape officer won't be assessing a proposal through the prism of the development plan. But that's not Ms. Reeves' role either, nor would a noise consultant perform it. It's for the planner and then the decision maker to analyse matters through the prism of the development plan once the extent of any harm has been determined. Mr. Raper conceded that he'd applied his planning judgment too early by deploying it to increase the level of harm up to significant. He ought to have taken the conclusions of the TVI forward into the overall planning balance, and then at that stage of the analysis, applied his planning judgment to determine what weight to give to the impacts identified and whether, against the overall planning balance, they were acceptable. The scheme would not result in design harm. Mr. Raper's particular concerns are the roof form, which is monopitched as opposed to dual-pitched, and the rear western elevation. As Mr. Pearce explained, pitched roofs are not unique to the design styles or time periods as are highlighted in the Alvey from Heath design brief, and the Council is in any event not suggesting that the design brief actually applies to the scheme. There's nothing, therefore, in the point made in the Council's closing on the lack of reference to the design brief in the DAS in Mr. Pearce's proof and so on. The design team plainly were aware of the design brief because the Council made clear reference to it in a previous pre-application response. A pitched roof would not have been appropriate for the scheme because it would have resulted in a significant increase in height that would have risen above the trees. As to the rear western elevation, the treatment's entirely appropriate. Any given retail unit will have one less developed elevation to facilitate servicing and so on. As Mr. Pearce explained, given that the trees and screening will be retained, it makes perfect sense to position that less developed elevation against the tree line here. The Council's design evidence betrays a fundamental misunderstanding of the appeal site's role in Alvetham Heath. The design brief requires landmark buildings to be provided in the local centre. It anticipated provision of a park and ride surrounded by trees on the appeal site. Mr. Raper's suggestion that if this site is going to be developed, the obvious cue is to take it from the local centre is misplaced. The context of the appeal site, surrounded by trees and screening, is obviously different from the context that those designing the local centre were presented with. Roof forms that were accepted for the local centre 30 years ago are not, as I've explained, appropriate for the appeal site. On the Council's gateway point, Mr. Raper in his proof points to paragraph 3.6.9 of the design brief, which states that a distinctive entrance avenue of trees will be provided from the southwest access point to the first roundabout within the development. The proposed tree avenue and new planting areas will be set within a 35-metre wide landscape corridor, and the use of new tree species and new rhododendron planting will provide an attractive and notable entry route into the site. First, that paragraph most certainly does not suggest that any built form on the appeal site should be taking cues from the landmark buildings at the local centre. Secondly, the scheme will support the design brief's intention for the gateway in this location because the gap that currently exists in the entrance avenue is located at the moment will be filled. Mr. Raper was simply wrong, as analysis of the related design brief drawings showed, to suggest that the 35-metre wide landscape corridor that's referred to does not include the gap that will be filled. It's common ground that the scheme won't impact upon the opportunity to use landform and vegetation to create entrances to the development that's identified in the design brief and referred to by Mr. Raper at his paragraph 5.8. As regards the design review panel, Mr. Raper was correct not to place any particular reliance on its comments, and limited weight should be attributed to the DRP's concern. It's unknown whether the DRP actually visited the appeal site. The appellant wasn't afforded any opportunity to present to the DRP, to make representations to it, nor even to witness the debate. The DRP's comments weren't provided until March last year, a full year after the application was submitted in March 2024, and no explanation's been given for those timings. Finally, as Mr. Raper acknowledged, the DRP's comments extend beyond their proper role because they express a view on the overall merits of the scheme and so on the overall planning balance. Finally, on design, the local centre is simply not as cohesive as Mr. Raper suggests. He accepted that the petrol filling station does not cohere with any other building in the local centre. The large areas of glazing on both the church and the Morrisons are significant contemporary design features. Mr. Pearce's unchallenged evidence was that the local centre buildings display adornments, but nothing more than nods to the styles that are referred to in the design brief. He was also clear that the local centre is, in his view, by and large a pastiche, and that the approach taken wouldn't be replicated if the master plan were being brought forward now. The buttressing to the community centre is a bit of a strange addition, in that it's almost a flying buttress. It's a nod to the arts and crafts style, but it's not a particularly successful solution. The tower feature on the Morrisons is a clear example of 1980s supermarket design introduced on the back of an Asda in Essex in the 1970s. With the buttress aspect being such a weak nod to arts and crafts that it was, in Mr. Pearce's opinion, really a pastiche. Buttressing in the arts and crafts style would have been a ground floor for structural support. Mr. Pearce considered the Morrisons to be a Morrisons of its time, with a few limited nods to arts and crafts, but very, very loose, and nothing at all on the petrol filling station. His overall assessment of the church was that there's a loose attempt to adorn a window and overhanging eaves, which could be attributed to the Victorian or Edwardian styles, but that are, in his view, clearly overridden by the building's height and glazing as a result of its ecclesiastical function. In response to paragraph 64 of the Council's closing, Mr. Pearce's evidence on the standard of design of the scheme was not unconvincing. It's unsurprising that he wasn't able to provide evidence on the instructions given to his practice, given that he wasn't with the practice at that point in time. The fact that he deliberated before confirming his view that the scheme is of high quality does not reduce the weight to be given to that response. It was entirely apparent to us all that Mr. Pearce was deliberating because the questions put to him suggested a distinction between good design and high quality design, which in his view could mean the same thing. When you, sir, posed the question more straightforwardly and asked, is it high quality in everyday language, yes or no, Mr. Pearce answered immediately and clearly. Of course, it must be acknowledged that the scheme's design has responded to the appeal site's context through the choice of materials, red brick and timber cladding, and the introduction of the colonnade to soften the north and east elevations, replacing what would be a standard canopy arrangement on a standard little store, and significantly reducing the visual aesthetic of the glazing, adding form and shading over that which would be found on a standard little store. Now, to be clear, there is nothing wrong with the standard little store in design terms. As Mr. Raper acknowledged, it reflects the design response that Lidl are satisfied will generally be adequate when assessed against planning policy and guidance. Here, however, that standard design has been progressed as summarised to respond to the specific context of the appeal site. As Mr. Raper agreed, very little, if any, weight should be given to the appeal decisions that he refers to at paragraph 640 and onwards of his proof, because those relate to different contexts. For example, one site was in an AONB. Turning to trees, the council's concern is that replacement planting will be insufficient in quantity, not quality. In the light of Mr. Raper's confirmation on this point in cross-examination, the submission made at paragraph 69 of the council's closing, which ends with an assertion that there will be a material net loss in terms of the quality of the trees that are lost, is simply not open to the council. Mr. Cleaves' evidence has established that the replacement planting will not be insufficient in quantity. 47 trees will be removed from the site, together with part of Group T1G. But the replacement planting will comprise 47 on-site trees and 8 off-site trees, that's as part of the BNG, and additionally 93 small trees, which are proposed as part of the on-site native shrub mix. Paragraph 69 of the council's closing is in error in suggesting that the figure of 47 replacement trees includes those within the BNG proposals, because the BNG proposals provide 8 off-site trees in addition to the proposed 47 replacement trees on-site. The existing scrub on the appeal site will also be improved as part of the BNG proposals. Mr. Cleaves' view is that in terms of the overall impact on planting, the replacement provision was perfectly adequate and would offset the proposed removals well. Finally, the initial impact on Group T1G could be reduced, as Mr. Cleaves explains in his proof, pursuant to a planning condition, if that were considered necessary. Turning then to planning policy, the scheme accords with the statutory development plan taken as a whole. To respond to the council's case, it's not likely to have a significant adverse impact on the vitality and viability of the town centre, and so there's no conflict with policy ED4. On policy Gen 1.1, the scheme is in keeping with the local character in terms of its design and landscaping, which are the only two aspects of the policy that are in dispute. It's common ground that there's no conflict at all with policy NBE2, which is the council's primary landscape policy. On NBE 9, it's common ground that there's no conflict with A, which doesn't mention either design or landscape. There is no conflict with D either. Having regard to the agreed conclusions of the TBIA, it's clear that the scheme does respect local landscape character and that it also respects views into and out of the appeal site. Mr. Raper agreed that the requirement to sympathetically incorporate any on-site or adjoining landscape features such as trees doesn't require the retention of every tree on site, and there's no conflict with that part of D. The appellant doesn't agree with the council's suggestion that the first paragraph of policy NBE 9 has independent life. Properly interpreted, it doesn't. A development that meets criteria A to J will also satisfy the first paragraph. Moreover, even if the council were correct to contend that the first paragraph does have independent life, the scheme achieves a high-quality design, and the other requirement is to seek to positively contribute to the overall appearance of the local area. There's no actual requirement to contribute positively, and so a neutral contribution doesn't offend that first paragraph. There's no conflict with policy INF2. As Mr. Cleaves explains in his proof, in context, the extent of the loss of GI would be very small. Mr. Raper accepted that not every loss of GI, however small, will necessarily result in a conflict with policy INF2A. Any infraction needs to be material. There would be no loss of connectivity, which is an important function of green infrastructure. Policy INF2 is primarily intended to protect against loss of green infrastructure functionality. Landscaping design issues, as we've seen, are primarily addressed through policies NBE2 and NBE9 respectively. As to policy INF2C, adverse impacts have been appropriately mitigated and the proposed replacement planting is of equivalent or better value in terms of quantity. Moreover, policy INF2 is inconsistent with the NPPF, and obviously so if the Council's now saying, contrary to Mr Raper's concession in cross-examination, that policy INF2A should be interpreted as being offended by every loss of green infrastructure, however small or immaterial in terms of the network's function. Mr Raper accepted that there's no equivalent policy in the NPPF, and that any conflict between the, scheme and the requirements of policy INF2 is not supported by specific national policy in the NPPF. The analytical exercise to demonstrate the inconsistency between policy INF2 and the NPPF is a simple one. If policy INF2 were worded so as to mirror what little is said in the NPPF about green infrastructure, there would be no alleged conflict with the policy. The appeal decisions on policy INF2 to which Mr Raper refers in its proof don't assist the Council. There's no indication of whether the question of the policy's consistency with the NPPF was even a point raised with the inspectors determining those appeal decisions, and the approach of one of the inspectors is plainly wrong in law, in that it applies policy INF2 to a site that does not even lie within the green infrastructure network. Finally, it's common ground that policy CON8 is inconsistent with the NPPF because it goes further than paragraph 136 of the latter. Turning to the Council's case on policy, in our submission, there's obviously overall development plan compliance if you reject the Council's case on design, character and appearance and trees, because if only the Council's retail case is upheld, the only policy conflict is with part of a single development plan policy, namely ED4. It is impossible to conceive of a lower level of conflict with the development plan as a whole. But even if the Council's case is accepted in its entirety, the appellant remains of the view that the resulting policy conflict is not so extensive as to result in overall non-compliance with the development plan. There's partial conflict with policy ED4, but not conflict with the sequential test aspect. The appellant doesn't accept the assertion at paragraph 80 of the Council's closing that the fact of only partial conflict with a policy does not or cannot affect the weight to be attached to that policy conflict. To the contrary, it's entirely appropriate that the weight given to conflict with a policy should reflect the extent of that conflict. There's conflict with only one of the 13 requirements of policy Gen 1, and then with only 2 of the 10 aspects that are listed in that first requirement, namely design and landscape. There's no conflict at all with policy NBE2, the primary landscape policy, and there is at most conflict with the first paragraph of policy NBE9 and with criterion D. The Council accepts that there's accordance with policy NBE9A. On policy INF2, Mr Raper confirmed that he wasn't arguing in respect of A, that there would be any fragmentation or significant impact on the function of the network. His point is that he says there would be loss, and he wasn't suggesting any conflict with B or D. On C, he acknowledged that you, sir, would have to take into account the extent of any failure fully to mitigate adverse impacts. And on the final paragraph of policy INF2, Mr Raper confirmed that he wasn't arguing that the proposed replacement planting would not be of equivalent or better value in terms of quality or accessibility. He was only taking that point on quantity. As I've mentioned, the appellant in any event considers policy INF2 to be obviously inconsistent with the NPPF. And again, it's common ground that policy CON8 is inconsistent with the NPPF. So overall, the scheme complies with the statutory development plan as a whole, and material considerations don't indicate that planning permission should nevertheless be refused. The NPPF is an important consideration. The appellant considers that paragraph 11D2 and the tilted balance is engaged because the basket of most important policies is out of date, having regard to the inconsistency of INF2 and CON8 with the NPPF. On the application of the tilted balance, the adverse effects of the scheme, which are not material, don't significantly and demonstrably outweigh its benefits, and so planning permission should be granted. Even if the tilted balance doesn't apply, so even if the basket of most important policies is up to date, such as a flat balance as opposed to the tilted balance applies, the benefits of the scheme still outweigh its immaterial adverse effects. Therefore, even on a flat balance approach, on which planning permission should be refused if the adverse effects simply outweigh the benefits, even if they don't do so significantly demonstrably, the evidence still indicates that planning permission should be granted. As the appellant explained in its opening statement, the scheme would bring into permanent productive use as PDL site that, despite sitting within the boundary of the settlement that heads up the council's own settlement hierarchy, has lain dormant, awaiting full permanent development for the best part of 3 decades. The scheme would additionally provide significant economic benefits in terms of job creation. It's passed the sequential test, and it would improve retail choice for shoppers, promoting competition with up to 30% cost savings. All of these points remain common ground at the end of the inquiry. As the appellant emphasised at the outset, the scheme's contribution to consumer choice is particularly resonant given the current cost of living crisis. Against the above package of benefits, the evidence heard at this inquiry has established that there are no material harms to weigh against the scheme, and that even if the 2 harms identified by the council are given significant weight in the overall planning balance, that balance remains firmly in favour of granting permission. And so for those reasons, we respectfully request, sir, that you allow this appeal. Sir, if I'm able just to respond orally to a few of the points that were raised in Mr. Neal's closing submissions,
Yes.
please. Sorry, where's my list? Yes, so paragraph 11, it said that Ms. Reeves explained that it was highly unusual for Waitrose to object. I'd ask you to note, sir, that Mr. Singer's evidence was to the contrary on that point. And then yes, paragraph 19 is suggesting that Ms. Reeves has carried out an assessment in relation to all the supermarket stores in Fleet Town Centre. I make the point, or I apply the point that I made in my written closing, sir, around Ms. Reeves' failure to work out where the discrepancy in turnover has actually been redistributed to. So this point about the 680% just being disappeared rather than redistributed, I make that point in response to what's said there. So you can check your own notes, but where it is said at paragraph 22 that Ms. Reeves's evidence was that the trade diversion from the Waitrose would be between £1 and £2 million. As you've seen from my closing submissions, my note is that she said it would be a further £1 to £2 million, and not just the figure of £1 to £2 million.
Okay, yeah.
Paragraph 30. Yes, this point about the M&S store opening at Farnham, of course, in the scenarios 3 and 4 in Mr. Singer's addendum from Monday, there's an assumption that 20% of the current M&S's trading will go to other M&S stores, and that includes the M&S at Farnham. So we say that point has been dealt with. Paragraph sorry, sir. Paragraph 31, there's reference to the PSA designation. I'd ask you to note that Ms. Reeves, the council's witness, placed absolutely no reliance on that PSA designation in her evidence or analysis. And then my 2 final points are paragraph 34, this point around the loss of 10,000 square metres of floor space, and that equating to between 1/4 and 1/5 of all town centre space in the Fleet Town Centre. My understanding from my discussion with Ms. Reeves is that that doesn't reflect the existing vacancies in the shopping centre. And we also would make the point that there is no evidence that national retailers would not go elsewhere in the town centre. And then my final response, let me just find the reference. Yes, this is paragraph 44B, where the point is suggested that NBE2, I think it is. Yeah, NBE2 only relates to rural landscapes, as I explored with Mr. Raper in his evidence. Absolutely nothing to support that suggestion in the text of the policy itself or the supporting text, so we don't accept that interpretation of that policy. But thank you very much, sir. That is what I wanted to say in response to the council's closing submissions.
Thank you, Ms Sargent. All understood. In terms of the cases, both very well put cases, and I'll carefully consider what you're both saying. However this turns out, I think they're very good cases, so I just want to make that clear. Before I look to adjourn or close the inquiry, are there any costs applications I need to consider? Take that as a no. So, I mean, that leaves a...
There's normally a pregnant pause when that happens, but no, not from the council, so.
No, sir, sorry. One of my applications on my computer is trying to crash it, which I think is why I was a bit slow to respond. But no, we're not making an application for costs. Okay,
thank you for confirming. And that leaves the residual matter of the planning obligation. And I've indicated during the round table that there's possibly a grace period of 1 week to allow the signing of that without prejudice to any outcome of the appeal. So unless it's received today, I'm proceeding on the basis that a week's grace is needed by the appellant. Is that right?
I'm sure we'd be grateful for that, sir. If Mr. Moyer has anything to the contrary to tell you, he'll speak up, I think. No, we'll take the week's grace period with thanks, sir. Thank you. Okay,
so what I'll do is I'll adjourn the inquiry on that basis. Unless anybody else wants to raise anything, I'll adjourn for 1 week, and then the inquiry will subsequently close in writing. That'll be confirmed to all other parties. So I don't think anybody else wants to raise anything. I can't see anybody in the background mentioning anything. So thank you everybody for your contributions, and I'm going to wish you all a good day. The inquiry is adjourned. Thank you.
Thank you.